What up, good people, family and friends? How y'all doing? It's Dark Angel. Hey, as promised, I know it's a few days late, but that's because of due to other important pressing issues that arose from the situation. Today, I am going to do a summary reading from this case right here that you're looking at, Hale versus Henkel. Now, I'm going to give you a little bit of inside information about this case, okay? First of all, this case has been brought forward to the Supreme Court 1,600 times. Maybe more by now, but 1,600 times since its induction back in 1906. So I just want all of you to know that all of you who's been citing the Maryland case, thinking that prohibits people from being able to travel without a license, registration, etc., that you got a case when you keep mentioning that case, the Maryland case. So guess what? Unfortunately for you, that case is null and void due to the fact that this case right here, Hale versus Henkel, has never been overturned and has never been superseded in 1,600 times that it has been presented in front of the Supreme Court. Just so you know, you don't believe me, look the history up on this case, okay? This case right here is set in stone. It is the law. And again, for all of you who think that the state has a right to regulate travel, you are wrong. The state was never given the authority or its police power to regulate travel. The only thing the state has ever been given authority to do was regulate its commerce. Okay? It was never given the authority or the power to do it, because if it had, this case wouldn't exist. And this case wouldn't be standing law today. So this case here, I need for all my private people to know and understand that this case is our case. This case is the case that puts the private where we are today. This case right here, if you should ever get faced with a situation where the police infringe upon that of your rights by wanting to illegally search your property, ask you questions and things of this magnitude, you might want to look to this case, because I'm going to tell you right now, this case right here has precedence. This case right here has standing, it has statute, it has structure. Most importantly, it is power, because this is the case that some of you may have heard, and you may have only heard the one part of the case that I'm actually going to engage in right here in this area, because what I'm going to do is I'm going to be skipping around to the main important parts of the case. Now, keep in mind, what I'm reading of the case is the opinion. The Supreme Court handed down a 47-page opinion in this case. Okay? I'm only reading from the opinion. Okay, so I'm not going to be addressing any of the other issues in this case. So you need to know and understand that what I'm reading to you is the law. It is not something made up. If you don't believe me, go look the case up yourself. Now, this case, as you can see, what I have here on my screen is printed straight from the book. I printed it from the book and I got it up here online so that I can post it up here online so that you can see it. And as you can see right here, this is the October term, as this case had progressed into the system. It was filed back in 1905, resolved in 1906. Okay, and as you can see right here, what it says, opinion of the court. So there's no question. If you just look at follow the top of my cursor right here, if you follow the top of my cursor, okay, that's what I'm going to use that as the underlying guide to go along in this case. So if you can read that, that's great. So in the opinion of the court, okay, this is what you're looking at. This is the opinion in this case. So thoughts of a patrol officer, all you police officers out there, you tyrants, you haters, you traitors, you constitution, you morons that think you know everything but don't know nothing. Okay? So this is basically for you, because all of us who are in the private, we're in the know. We already know. And we already know what Woodrow Wilson had already set forth as a plan to educate the court system into being stupid whenever someone figures out what the actual initial plan is of the United States. So we already know, and we already know what you think about the citizens of the United States. So but anyway, I'm not going to get into all that, because I'm going to get into this, because this right here is a little bit more important. And I am actually going to start this case off with the reading right about here where it says conceding. So if you can see that, awesome. Okay, so let's see. Let me see. Because this is important for y'all to know. So conceding that the witness was an officer of the corporation under investigation, and that he was entitled to assert the rights of the corporation with respect to the production of its books and papers, we are of the opinion that there is a clear distinction, are you listening, people, in this particular between an individual and a corporation, and that the latter has no right to refuse or submit its books and papers for an examination at the suit of the state. The individual, here you go, people, may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation. Let me repeat that part. Or to open his doors to an investigation. When you get pulled over, police pull you over and they start asking you 1,000,001 questions, you always need to know that your that your rights trump statutes every day. You need to know that. Okay? You also need to know that when you plead the fourth, the fifth, okay, when you take and plead the fourth and the fifth, you answer no questions. That is your right. This case right here will get your charges dismissed every single time, as this case right here has never been overturned or superseded. That's for anybody and everybody who needs to know that. You're looking, I noticed that a lot of people have been asking me, man, I need cases that hasn't been overturned or superseded. Well, here you go. Here's your power case. Never been overturned or superseded right here. History on the case: after I did a lot of extensive research, I determined that 1,600 times this case has been presented in front of the Supreme Court, and 1,600 times it's stayed. So, what I am reading to you is law. Now, the police can mess around and find out if they want to, but, that's what they're just going to have to do. They're just going to have to mess around and find out. You know what I'm saying? So, yeah, let me get back where I was at, because I just lost my deal. Okay, so, and again, it says, or to open his doors to an investigation, so far as it may tend to incriminate him. Okay? He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. And I don't think you guys can see that, so let me go back up here. And I wasn't paying attention to my screen over there, and I didn't realize that you guys couldn't see that part. And for some reason this thing is just dropping too many deals. Yeah, I didn't think you guys could see that. I just caught that out of the corner of my eye. So bear with me, guys, because I'm learning this stuff too. And I think what it is I got to get my cursor, the lines, they're just way too many lines that this cursor is allowing to go through. So there we go, right there. So we'll do it like this. We'll set it up like that. There we go. Now, so then let me see now. Okay, so we were right here. To open his doors to an investigation so far as it may tend to incriminate him. Okay, he owes no such duty to the state since he receives nothing therefrom beyond the protection of his life and property. Okay, the reason why I'm having a little trouble with this is because I'm trying to set up something for me that I'm comfortable with, so that I can get this information out to you guys, because of the simple fact is this is what they don't want you to know. Now here's the thing, when you look this case up, this is the part of the case that they show you. Some of the parts of the opinion that I'm going to read to you, they never publish it. It's never published, so you have to go and get the entire case in order to read the part of the opinion that I'm going to read to you. Okay, because it's not published online. You know, I mean, you can get the case online. You can go to the law library like I do and get it, like I did here. So you can go online and get the case, but be wary, okay? Because, like I said, sometimes some of those cases are altered, and as you can see from what I have here, this is the actual original case. See? And this is all the opinion. This is all the opinion of the court. See, opinion 72, page 70. And like I said, this is a 47 page opinion that these judges handed down. Okay, so you know, yeah. And this is the opinion, so this is law. So it's not that anything trumps it. It's his law. Okay. Okay, so we were back here, so far as it may not tend to incriminate him. He owes no such duty to the state since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long existent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and the immunity of himself and his property from arrest or seizures except under a warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. So you got to keep that in mind, because like I said, this is the opinion of the court, so it's law. And they, unless due process has been served, they cannot act. Okay, so your property is yours, it's secure. So hence the reason why the Fourth Amendment says you have the right to be secure in that of your person, property, papers, and effects. Okay, so we're going to go ahead and keep on going now. Upon the other hand, the corporation is a creature of the state. Okay, now this is the opinion now. This is the opinion, so it's law. So this is what they're telling you. A corporation, which the United States is a corporation, it's a creature. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises. and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law, and it can make no contract not authorized by its charter. Its rights to, hang on, whoops. Its right to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislator to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state having chartered a corporation to make use of certain franchises could not, in the exercise of its sovereignty, inquire how these franchises have been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose. Okay, so you know, and like I said, you know, the corporation, you know, they can refuse to produce books and papers and things of this magnitude. The individual, I'm sorry, the corporation cannot refuse to produce its books, papers, and effects. Okay, whereas an individual can. Okay, because the thing is, you know, so anyway, the bottom line is what I'm getting ready to get into is parts of the case that they never tell you about. So while an individual, whoops, let's go up here. Here we go again with this long thing. I think I gotta go in here. While an individual, God dang it. Okay, hang on people, hang on. This right here is starting to get on my nerves. It's not cooperating. Okay, so and it does not wish to cooperate. So what we're going to do is we're going to do that, and then we're going to take this and see where I'm at. It wants to read right here, so I'm reading right here, but when I go to do my cursor, it takes it, the part that I'm reading, and puts it way up there. So yeah, I think that's a cursor adjustment. So just bear with me when you hear the words, because I'm going to read down in here to where it gets to the point, and then I'll try to scroll up so that you can hear what it's saying. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, it does not follow that a corporation vested with special privileges and franchises may refuse to show its hand when charged with an abuse of such privileges. Okay? It is true that the corporation in this case was chartered under the laws of New Jersey and that it receives its franchise from the legislator of that state, but such franchises, so far as they involve questions of interstate commerce, must also be exercised in subordination to the power of Congress to regulate such commerce. And in respect to this, the general government may also assert a sovereign authority to ascertain whether such franchises have been exercised in a lawful manner with a due regard to its own laws. Being subject to this dual sovereignty, the general government possesses the same right to see that its own laws are respected as the state would have with respect to the special franchises vested in it by the laws of the state. The powers of the general government in this particular, in the vindication of its own laws, are the same as if the corporation had been created by an act of Congress. It is not intended to intimidate, however, that it has a general visitorial power over state corporations. Okay, so, you know, basically what they're saying is the state can only control its corporations. All right, has no control over private individuals. So now we're going to take and move on through. I want to take you guys to page 84, 83 of this opinion. Yeah, here we go. So we're going to go to page 83 of the opinion. And let's see, we'll start here at the bottom right here. And we'll start the protection of both the amendments. Let's see, hang on a minute. Okay. The protection of both amendments, it can be contended, is against the compulsory production of evidence to be used in criminal trials. Such warrants are used to aid of public prosecutions. Cooley Constitutional LIM 6th edition 364, and in Boyd versus United States 116 U.S. 616, a relation between the Fourth Amendment and the Fifth Amendment was declared. It was said that the amendments throw great light on each other for the unreasonable searches and seizures. Okay. Deemed in the Fourth Amendment are almost always made for the purpose of compelling a man to give evidence against himself, which in criminal cases is condemned in the Fifth Amendment, and compelling a man in a criminal case to be a witness against himself, which is condemned in the Fifth Amendment, throws light on the question as to what is an unreasonable search and seizure within the meaning of the Fourth Amendment, and we have been unable to perceive that seizure. And yeah, I am definitely going to have to readjust this cursor deal here. Let's see where I'm at. Okay, that the seizure of the man's private books and papers to be used in evidence against him is substantially different from compelling him to be a witness against himself. Oh, and I'm hating this right here. Which is condemned in the Fifth Amendment throws light on the question as to what is unreasonable search and seizure within the meaning of the Fourth Amendment, and we have been unable to perceive that the seizure of a man's private books and papers to be used in evidence against him is substantially different from compelling him to be a witness against himself. Now you can find all that in Boyd, but the thing is what I want to get to is actually I want to get to page 86 of this opinion so that you can see 86 right here. So here is the part of the case that they don't talk about. Okay, so you go here at the mischief intended to be reached by the statute is the same whether it respects private or corporate persons, that corporations are in law for civil purposes deemed persons is unquestionable, and that the citation from Second Institute 736 established that they are so deemed within the preview of penal statutes. Lord Coke there in commenting on the statute of 31 Elise E7 respecting the erection of cottages where the word used is no person shall, etc., says this extends as well to persons politic and incorporate as to natural persons whatsoever. Neither does the fact that a corporation is engaged in let's see, I lost it. Neither does the fact that the corporation is engaged in interstate commerce in any manner abridge the protection and applicability immunities accorded by the amendments. The corporation of which the petitioner was an officer was chartered by a state, and over it general government has no more control. Listen to this here, you guys, because here's where it's at right here. The state, and over it the general government has no more control than over an individual citizen of that state. Its power to regulate commerce does not carry with it a right to dispense with the Fourth and Fifth Amendments to unreasonably search or seize the papers of an individual or corporation engaged in such commerce, or deprive him or it of any immunity or protection secured by either amendment. It is true that there is a power of supervision and inspection of the inside workings of a corporation, but that belongs to the creator of the corporation. If a state has chartered it, the power is lodged in the state. If the nation, then in the nation, and it cannot be exercised by any other authority. It is in the nature of the power of visitation. Okay? So I hope that you guys just understood what that was, what that just said. So, the state has the power to regulate its commerce. Nowhere in there did it say that it had a right to regulate private individuals. Only time the state has the authority to regulate a private individual is if that private individual is operating in commerce. If that private individual is operating under commerce, then that is the creation of the state, and the state has the right to regulate it. Basically is what that case is saying. So you can operate in the private and be operating in commerce as well. So keep that in mind. That's the whole point of that's the reason why they have private carriers in the 18-wheelers truck driving jobs. Okay? So, and that's something that you guys need to know and understand, because in that field of work, right, that comes under strict regulations, and that actually comes under the FMCSA, which you guys know already through many of my videos. I'm always showing you this book right here. This is the book when they tell you about the safety for the public, the welfare and well-being of the public. They're going from this book right here. And as you can see, that says Federal Motor Carrier Safety Regulations. Now, you don't get a automobile safety regulations manual. There's no such thing. I've never seen one produced, and never seen one ever handed out when you purchase an automobile. So, and there's a few other things that you need to know, that when you purchase an automobile and you go have it registered, your automobile is reclassified as a motor vehicle. If you look at your title, you'll notice your title says motor vehicle on it. It doesn't say automobile. You see, so and per the definitions, per the federal code and the United States Supreme Court, as well as Black's Law Dictionary, etc., etc., motor vehicle is a classification of a commercial conveyance. Okay, so yeah, and so the other day, I think it was yesterday, as a matter of fact, I was reading up on some of the Washington codes here in Washington, and I discovered something that I didn't realize until I actually read it. So under the Washington Code 4620, RCW 4620, it says that anyone who wishes to drive on the streets of Washington must have a valid driver's license. So, and it issued under that code. Well, when you read that code, that's all that code says, is that. It does not give a line, or, that's actually more or less like just a note saying that under 4620 you have to have a driver's license. Okay, so under 4620, nowhere in its face does it say driver's license. It just says you have to have a valid driver's license. But here's the thing, when you go down to 4625, interestingly enough, it refers back to 420. And in 4625, it tells you that in order to operate a motor vehicle, one must have a valid CDL issued to them under Chapter 4620. Hey, imagine that. So, when you look at that, it actually says CDL CPL, which is certified permit or commercial permitted license. So when you look at that and you read the entire chapter, the only license that's mentioned throughout the entire chapter is a commercial license. Nowhere on its face does it mention anything about a standard license, a non-commercial license, which, if you're like me, you already know. Commerce means to do business or trade, period. Anything dealing with the DMV pursuant to that of what Reno versus Condon says, and this case here, Hale versus Henkel, is everything dealing with commerce. Any parts of the highways, that's all commerce. Okay? Any license, you need permission. So you need permission to operate in commerce. And that's basically what they're saying. So your permission is a privilege. Okay? Travel is a right. It's always been that way. Every court has ruled on that. And the thing is I keep hearing people say, well, you can travel, you can walk, you can ride a bike, you can do this. Well, you show me the law that says the state has been given the authority to tell me how I can and cannot travel, or what I can and cannot use to travel. There is none. There is no case. And that's why you defeat the argument every single time, because there is no authority or case that says that if an individual decides to travel and he doesn't have a driver's license, he has to walk, he has to ride a bike, he has to pick some other means other than an automobile to do so. There's no case law that says that. And if there is, correct me if I'm wrong and show it to me. Don't give me your opinion, because your opinion is just like assholes. Everybody's got one. So, and I've always said that if you have an opinion, then your opinion alludes to that of intent. So you might want to be careful as to how you voice and what you voice in your opinion, because your opinion always alludes back around to the intent. So again, as I'm sitting here and I'm trying to understand where these so-called people who do not agree with individuals who stand up for their rights, because they'd rather sit down on their asses and do nothing and make mockery of what is actually the law. And for those ones that are sitting don't seem to understand that common law is the law of the land. It's a fact. Common law is the law of the land. So, but you have all these so-called lawyers. They're getting up on here. You don't know you need a license. You need it. No, you don't. You're not operating in commerce. And until the courts rule that the DMV is not commerce, it is what it is. It's commerce. And it's going to remain that way for, whenever. But the bottom line is that the DMV, people, you need to understand, the DMV has only ever issued one license. Yeah, you have a motorcycle license, but then you have one license that has ever been issued by the DMV. The classifications of the license does not make it different license. And that's the issue. One of the issues that someone who was commenting a while back was having was, yeah, but you have classifications A, B, C, and no. Classifications of a license, all that is a classification A, B, or C. If you have a classification A, it gives you authority to do everything in B and C. If you have a classification B, it gives you the authority to do everything from B and C, excluding A. If you have a classification C, it allows you to do C and only C, excluding B and A. So you can't have a class C and operate under a class A function or a class B function. That's what the classifications do. It gives the license authority to operate in a particular capacity. That's the only authority that one license has. When you get your license, pull your license out of your wallet and see if your license has on an END. I promise you it does. END stands for endorsements, people. That's commercial. Somewhere on your license face, or either on the back, on the reverse side of it, it says there's somewhere it's printed CDL on it. All licenses are commercial. They always have been. Every license ever issued in the United States of America since the turn of the century, maritime law, admiralty, all this, it's always been for commercial activity, to govern, track, and control the flow of commerce, so that they knew where the business was going and how it was going and how to regulate it and to keep people safe. This is what you keep hearing in these cases about the state has a right to regulate its commerce in the interest of the public safety and public health. They're talking about this. They're not talking about anything else. There's nothing else mentioned. There's nowhere in any of the case law does it say anything about travel. It can't. Travel is an inherent right. You was born with that right to do that. That's an inalienable right. Man did not give you that right. Man can't take it away. Why do you think all of us are winning in courts with these cases? Because we know the common law and we know what case law to use, and it's not manipulating the law. It's not, trying to play a game or anything to that magnitude. It has nothing to do with that. It's utilizing the law that was set forth, that was given, to protect rights that man never gave us. Man can't tell me that I can move around this way or I can move around that way, or I have to be able to move around in a certain capacity, or utilize a certain means of transportation to get around. My right to locomotion is my right to locomotion. Oh yeah, and by the way, there is a case law that actually says that the right to locomotion is a right. And if you read some of the other cases that are out there, they actually tell you that travel is a right, not a privilege that can be prohibited or permitted at will by the state. State can't prohibit it and it can't permit it. And that right there should tell all you knuckleheads what it is. That should have told you right from the beginning. If a state can't prohibit or permit the right to travel, but they are allowed to regulate their commerce, that should have showed you the line of separation. The state can't prohibit or permit at will someone's right to travel, but they can prohibit or permit someone to operate in that of commerce. And based on the fact, like for instance, one of the encroachments upon one of the freedoms is, like, your liberty is, and actually you have to keep in mind this can actually work two ways. So you can lose your right to freedom if you commit a crime, and through due process and lawful conviction, convicted of a crime, then you can be incarcerated. So you lose your freedom that way. And you basically, by having committed the crime, voluntarily gave up that liberty. See, that's one of the ways you can lose your rights. As an example of how your rights can be lost, you know. So, and that right there is probably one of the best ways that I can explain how your rights can be lost. Now, under a right to travel, I've actually had someone bring this up, which I found it interesting. They said, yeah, but if you have a suspended driver's license or an expired driver's license, you can't travel. Yes, you can. If you have a suspended driver's license and you decide that you want to travel, you can. My wife's done it. She has a suspended, listen, my wife has a suspended driver's license. She does have a suspended driver's license, okay? And she even has a failure to appear for that suspended driver's license, okay? This is facts. This is facts right here. What I'm telling you, this is facts. She was pulled over and told the officer, look, I'm not driving, I'm traveling. And this was back last year, I believe. It was winter. I did a video on it. Go in my videos and look. You'll see where I'm wearing a Carhartt work jacket. And actually, I was doing my conversion van. I was actually in the process of building that van, and I shot the video inside that van. Cold at that time when I was doing it. But the point is she came home and she told me what happened. She gave me the information as to what happened. Unfortunately, she didn't get it on video because it was her first time. You know, so she was nervous. But now it's pretty much set in stone in her head that if she should get pulled over, you know. But here's the thing. Now, get this. So they tell you that a driver's license is required in order for you have to have some form of ID, valid driver's license, state ID, or whatever, in order to get your car registered, get plates on your car, etc., etc. Well, I'm going to tell you something. That ain't true. On her car, now she doesn't have the private plates on her car like I do. She actually has plates on her car in my name. I don't have a driver's license. I've never had one. I've had a CDL when I drove 18-wheelers. That was actually suspended, and then it expired. So therefore, the contract was ended. And then what I decided to do was go ahead and rescind that contract, which I did. I rescinded it and just grabbed me a regular state citizen ID card. So, which I carry with me. So with that being said, you know, the car has plates, tabs, and registration in my name. So and she went to the DMV and renewed them on my behalf without paperwork or without anything. Okay, she went up there, she told them she needed to renew the tabs on the car, and they renewed the tabs on the car. Without, I'm quite sure they probably asked her for ID or whatever, and she probably gave them her ID, but everything is in my name on that car. But there is no registered license on that car. Now, pursuant to rules and regulations, you have to have and show some form of ID in order to have plates and tabs on the car. It's not true. It's not true to any degree of the word. You know, all these states, I was watching a video this morning, and unfortunately I couldn't get it recorded. But I was watching a video where a gentleman was trying to rescind his license and turn his registration in, and the lady at the DMV played like she was just the most ignorant, most dumbest person in the world, and continuously tried to persuade him and convince him that in order for him to operate his automobile on the roads, he would be subjected to have to pay taxes. Now, he wrote a letter of intent and filed it with the county clerk that this was his property. Okay, so that's another thing that I'm going to get into too in a video about filing with your county clerk recorder a letter of intent. Okay, as far as what your automobile is. Now, these are the easy steps that you can utilize to get your automobile, because this way it's on record, and then you file a notice of liability as well with that letter of intent. You file that, you put it all together, and that car is on that automobile. Your personal automobile is in the record, public record, as intent to not operate in that of commerce, but for private pleasure, and it will never be used as commerce. Now, should you decide to do it, then you need to go get the proper paperwork, get your license, get your registration, etc., etc., should you decide to operate in commerce. Okay, but that's one thing that these police, they're not educated in, and we already know this, that they don't understand that everything in the DMV is commerce. It's commercially related. So it's one and the same. There's nothing special about it. So, I'm rambling on and getting on with this, but I'm going to go ahead and get out of this. Now, I want to take and apologize for the quality of the video during the reading of the opinion of that case. I urge you guys and girls alike, brothers and sisters, doing this free, I urge you guys to get this case. Okay? Get this case, and I want you to focus your attention on these pages, because now on page 84, where you don't have to open your doors to investigations, that's the majority of the publication of this case that they publicize. Okay, you will find that online. You can go online, look this case up, and you'll see that part of the case that I've read to you about, you do not have to open your doors to investigation. You don't have to indulge your private business to anyone. You can go on about your private business in your own way. Now, if you're traveling, that includes travel. You can travel in your own way. That case set precedence right there. So that's something that you need to know and understand. If it alleges that a private individual can go on about their private business in their own way and manner, that means travel too. That includes anything and everything dealing with that private individual, which includes travel, and it can't be regulated. And that's what people don't understand. Your rights can't be regulated. The regulation, let me rephrase that. So, your rights are regulated if you commit a crime. And if you commit a crime and you are lawfully convicted of that crime, okay, then your rights are regulated, and the regulation is incarceration. Okay? So let's not be out there doing crime, y'all. Let's not be committing crimes, man. We don't need that. You don't need that on you, and you don't need to be spending all that time, behind bars. It doesn't take nothing to be a good person. Be a good person. You know, be a respectful person. Be an honor. Be a king if you're a man. Be a queen if you're a woman, and be in honor. Do it in honor. Okay, that's what I want you guys to know. Be kings and queens in honor. You know, that's all I really can say. You know, but again, I would apologize for the quality of the video, but I urge you guys to get this case. Okay, Hale versus Henkel. I really do urge you guys to get it, because this right here is a power-packed punch for your arsenal. And honestly, I'm going to be honest with you, it's probably the strongest case you're going to have in your arsenal is this Hale versus Henkel case, okay? So I just want you guys to see it one last time. There it is, right there. So you guys need to get this, okay? Because like I said, this is what I've been reading to you. Okay, this is the October turn statement of the case. Okay, and statement of the case, it keeps going down. So argument for the appellant. Okay, and everything that I read to you from page, what was it, 74? Well, we can go here, yeah. Argument for the United States. So you have the argument for the United States, you have the argument for the appellant, you have the statement of the case. Okay, the opinion starts on page 58, and it is titled October Term 1905. And the opinion runs all the way through from there to the end of the case. Okay, 40 something odd pages of opinion. Okay, so once you get down there, then it gets down to the bottom and it shows who concurred, who you know, who went from it, you know, etc., etc. Okay, and as you can see, all the judges actually on this particular deal, they concurred. So, you know, they all concurred in reference to this. I don't think too many of them descended. As a matter of fact, I don't see any of them that descended from this reading. So you had all the justices on this case. Oh, here goes one descending. So you have one dissension right here, which was Brewer. And okay, so that's still Chief Justice Brewer's dissension. So he was the only judge out of the judges that dissented. Okay, so and again, his dissension doesn't mean anything. Okay, now if the dissension was the meaning as was the reason as to why the case was ruled on, then that would be the law. However, being that he was the only one that dissented and everyone else concurred, you can pretty much establish what actually happened in that case. Okay, so the case is solid. It's 100%. Like I said, do your homework on it. Look it up. Find the history on that case, and you will see that it actually says that the case has been brought forth in front of the Supreme Court 1,600 times, never superseded, and never overturned. Now, this case was decided in 1906, filed in 1905, or possibly 1904, but I'm going to say 5. So, you know, with that being said, you know, that just goes to show you it's been well over 100 years that this case has been in operation. So, or just right there at, you know. So, with that being said, just know that with this case you can't go wrong. State only has the authority to control, regulate its commerce. Period. Alright? So, with that being said, if you understood, congratulations, you just got a higher step in your learning. If you don't understand, then I suggest you sit your butts down and get some reading under your belts and get some understanding. There is a difference between commerce and travel. One is a right, one is a privilege. Dark Angel, deuces.